Hi, Tom. Today we're going to talk about unlawful presence and the 3 and 10-year bar. First question is, what is the 3 and 10-year bar?
Well, a bar is a prohibition. It just tells you something you can't do anymore. So for the 3 and 10-year bar, the bar says that you are prohibited from obtaining any kind of visa, whether immigrant or non-immigrant, until you have resided abroad in your home country of residence. This bar applies even if a family member petitioned for you many years ago, and even if you marry a U.S. citizen.
Does it matter if you are in or out of the United States?
No. The bar can apply to you when you are outside the United States applying for consulate processing of a visa, and it can be applied to you if you are in the United States applying to change your status or adjust your status.
What makes the bar go into effect?
The act of leaving the United States to visit or travel abroad after you have been unlawfully present inside the United States activates the bar.
How old do you have to be for the bar to go in effect?
18. Only time spent in the U.S. after the age of 18 is counted for purposes of determining the period of unlawful presence in the United States.
What is unlawful presence?
If you are a foreign national, you can accrue unlawful presence in the United States. There are 2 ways this can happen. 1, you can enter the United States without a visa. If you enter without a visa and are not inspected by an immigration officer, you begin to accrue unlawful presence inside the United States the day you arrive. But remember, only time spent in the U.S. after the age of 18 is counted for purposes of unlawful presence. Second, if you enter the U.S. legally on a visa, but you overstay your visa, you begin to accrue unlawful presence the day your authorized stay expires. If you enter the country on a temporary visa like a tourist or a business visa, the date your authorized stay expires is written on the white card that is placed in your passport. This card is called an I-94 departure card. The date on the white card, not the date on the visa in your passport, determines the date your status expires.
Okay. Aren't there any recent changes regarding the I-94 departure record?
Yes, there are some changes. Immigration is doing away with the issuance of the white card. Instead, the information is entered into the USCIS computer system, and the date your stay expires is written inside your passport.
What is the difference between the 3-year bar and the 10-year bar?
Which bar applies to you depends on how long you have been unlawfully present in the country. If you have been unlawfully present for more than 6 months, but less than 1 year, the 3-year bar applies to you. If you have been unlawfully present for 1 year or longer, the 10-year bar applies to you.
So if I'm in the country and have an unlawful presence for more than 6 months, does the bar automatically apply to me?
No. For the bar to go into effect, you must leave the United States to visit or travel abroad. Only the act of leaving the United States activates the bar after you have accumulated unlawful presence.
Can't you simply avoid the bar by not leaving the country?
You could, but it's not that easy. Sometimes people leave the country because close family members abroad are very sick or are dying. But even if you leave to visit a sick family member, the bar could be activated. There is no exception for family medical emergencies or other family emergencies.
What if the U.S. Department of State has scheduled for me an interview at a U.S. consulate on an approved family or work visa?
Well, if you enter the country without inspection and you want to legalize your status, you're not going to be eligible to process your case inside the United States. So you're going to have to leave the country to process your case at an embassy or consulate abroad. But if you leave the U.S. to attend the interview at the U.S. consulate, that departure will activate the bar. There is no exception if you leave to process your case with the U.S. Department of State. This is a catch-22 situation for many people.
What can I do to avoid the bar?
Some people qualify for a waiver. You can apply for a waiver of the 3 or 10-year bar if your departure would cause extreme hardship to a spouse or a parent who is either a citizen or a lawful permanent resident. The waiver does not include hardship to children who are citizens of the United States or residents of the United States.
How can I apply for the waiver?
There are two ways. You can apply for a provisional waiver before you leave the United States to attend your visa interview, or you can submit the waiver application after the interview at the consulate. The advantage of applying for the provisional waiver is that you know before you leave if immigration is going to approve the waiver of your unlawful presence.
Does an approved provisional waiver guarantee that I will be issued a visa when I go to my appointment at the U.S. consulate?
The provisional waiver only addresses the issue of unlawful presence. Other issues, like your medical condition, your immigration record, or your criminal record, could be used to deny your case.
I have heard that there is a permanent bar related to unlawful presence. What is the difference?
The language of the permanent bar does create confusion because it also talks about a 10-year period. If the permanent bar applies to you, you can apply for a hardship waiver, but you have to reside outside the country for 10 years before you can even submit the hardship waiver.
What activates the permanent bar?
If you already have a period of unlawful presence over 1 year and you leave the U.S. and re-enter the United States without a visa or inspection, the permanent bar applies. Unfortunately, the permanent bar comes up for many people who have left the United States to visit relatives in their home country and then return without a visa to rejoin their families. And it gets worse. If you have been apprehended by the U.S. Border Patrol attempting entry, this can be evidence of your departure and alert immigration that the permanent bar applies.
Well, thanks, Tom. If people have more questions, how can they contact you?
They can call me at my office at this telephone number, 707-747-5133, or they can look me up on the web at www.thomaslangfordlaw.com.
Again, thanks, Tom.
Thank you.